Well, good morning. It's 8:36 on Wednesday, March the 18th. The House Criminal Justice Subcommittee is now in session. If everyone please sign in for roll call. Madam Clerk, take the roll.
Mr. Chairman, you have 8 members present. You have a quorum.
Thank you very much. Personal orders this morning. Scarborough, Representative Scarborough.
I think we got some local law enforcement officers in the room today. If you raise your hand, you know.
All right. Thank y'all for being with us.
They missed the memo.
Anyone else? Personal orders. I've got with me Mr. Brian Hirschler. He's a shadow today. So thank you for being with us. All right, we have a very lengthy calendar. We are going to be skipping around considerably today. So when you hear your name, be prepared. But before we get started, item number 1, House Bill 1547 by Representative Kiesling is off notice. Item 24, House Bill 2479 by Representative Parkinson is off notice. Item 29, House Bill 2346 by Representative Harris is off notice. Item 32, House Bill 1022 by Representative Russell is off notice. Item 45, House Bill 1233 by Representative Gillespie is off notice. Item 68, House Bill 2575 by Representative Kumar is off notice. Brings us to item number 2, House Bill 2023 by Representative Martin. You're recognized. There are no amendments.
Thank you, committee and chair. You're accurate. There are no amendments. Good to go.
Have at it.
Thank you, guys. This is involving the victim assessment fee. Currently, it's set at $45. This bill would move it to $125. As you guys know, this provides funding for our wraparound services for domestic violence and child services, such as Carl Perkins, CASA, and what that would do would allow those dollars to be earmarked specifically for those funds from our county government. $15 would still stay with the clerk for administrative costs, but the rest would go directly to that, saving funds out of our general budget from the taxpayer and going straight to those providers.
Thank you for that explanation. Questions for the sponsor? Seeing none, I do have a question. This will have to be adopted by the county commission. Will have to adopt this fee increase.
Yes, sir.
All right. Anyone else? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 2023 to full judiciary. Has everyone voted? Does anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 8 ayes and 0 noes.
Thank you for that. The ayes prevail. House Bill 2023 moves on to full judiciary.
Thank you, committee and chair.
Item number 3, House Bill 1471 by Representative Hicks. You're recognized. There are 2 amendment codes here. You wish to do one, both? Combination there.
The amendment that we choose to put on is 015621.
Amendment code 015621. All right, you're recognized on the amendment.
Thank you, Mr. Chairman. This amendment creates a limited pilot program in Northeast Tennessee to expand access to drug court treatment, or otherwise known as recovery court. This gives judges the discretion to admit appropriate participants. This is not automatic eligibility. It maintains strong public safety guardrails by excluding true violent offenders, those involving weapons, serious injury, and prior violent felonies. It focuses on nonviolent individuals struggling with addiction, where treatment is proven to reduce repeated crimes. This is a temporary pilot program through 2028, so we can measure the results before expanding anything statewide. This is a smart, controlled way to get people into recovery, reduce recidivism, and protect public safety at the same time. Thank you, Mr. Chairman.
Thank you for that explanation. Does the amendment make the bill?
Yes, sir.
Does Leader Lamberth question on the amendment? A question on the bill, okay. Anyone else have a question on the amendment? Seeing none, we're voting now to adopt Amendment Code 15621 on the House Bill 1471. Those in favor will say aye. Aye. Those opposed, ayes prevail. You adopt or own your bill as amended. Leader Lamberth.
Thank you. And to the sponsor, just curious, why the amendment? Statewide, judges should have more discretion on who comes into the drug court programs and the recovery court programs. And then in our district, we have mental health court, we have, I think, a veterans court, we have drug court, we have DUI court. They've got a treatment court for just about any malady that somebody is suffering through. And every year there's people that get turned away from that because of something that's in their history that both the district attorney's office and the judges say, well, look, that person would really be a good participant. So why the change?
Mr. Chairman, thank you. The reason for the change is it's hard for mental health and substance abuse to really figure out exactly what kind of a cost this is going to be across the state. I agree. This needs to be 100% across the state, but it's one of those things. It's for them is extremely open it statewide. It would be hard for them to know exactly how much what the physical note would be on this. It's hard to estimate. So I think that's the reason for the amendment. I would love to see it statewide.
Yes, sir.
I will say on amendment coded 11521, the fiscal note was not significant. On 15621, it says memo not yet available. So I hope it don't head in the wrong direction for you. So anyways, just a thought. Thanks. I appreciate you bringing the bill. Seems like a good piece of legislation.
I will say, Leader, the amendment or the fiscal note did come back this morning. It was not significant.
There you go. Still good.
Any other questions for the sponsor on the bill as amended? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 1471 as amended to full judiciary. Everyone voted. Anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 8 ayes and 0 noes.
The ayes prevail. House Bill 1471 as amended moves on to full judiciary.
Thank you, Chairman. Thank you, committee.
Item number 4, House Bill 1678 by Representative Sparks. You're recognized. There are no amendments.
No, sir. Thank you, sir. House Bill 1678 basically is increasing the penalties by one level on introduction of contraband to our penal facilities, which results in the death of someone. As you know, we've had a rash of increased drugs, whether it's fentanyl or cell phones into our correctional facilities and our jails, and this seeks to increase the penalty. Currently, it's a Class C felony to take weapons. Will be a Class B if death occurs, Chairman. Currently, it's a Class D felony to take in drugs. It'll be a Class C if a death occurs. Currently, it's a Class D felony to get a telecommunication device into a penal facility, which will be a Class C if a death occurs. And currently, it's a Class E felony to possess telecommunication device without approval. It'll be a Class D felony. With that being said, I'd like to ask for your approval.
Thank you for that explanation, Representative Powell.
Thank you to the sponsor. Could you give me an example of the part that I guess concerns me is with the phone? How could you give an example of how a phone could result in the death of someone and how that would be?
I really couldn't, sir. I don't have an example. I just know that a mother come by my office in tears, had a son and 33-year-old Christopher Farley, and someone smuggled in fentanyl and he passed away, left 5 kids behind. And I think we all know it's a problem. I don't have an answer to that one, Representative Powell.
And I guess as a follow-up, could we go out of session and ask legal that? How a contraband?
Yeah.
Or if somebody can answer that?
Leader Lamberth may be able to answer that.
I don't mind answering because I know the sponsor, I'm a co-sponsor in the bill, and he brought the bill after conversations he and I had. He's had issues in his district. I have in mine. On the cell phone, people are not smuggling cell phones into jails to call their family members and check in and see how things are going. In large part, they're smuggling cell phones into jails so that they can engage in criminal enterprises outside of the jail. outside of the prison. And so if, for instance, say someone had smuggled a phone into a prison or a jail and then used that phone that caused somebody else's death. And unfortunately, in some of the gangs out there and other stuff, I mean, you get folks that try to do that. They continue their criminal enterprise inside a prison, inside the prison walls with cell phones. And so it's not something that's going to happen very often. I think it would be a very rare occurrence that could occur, but it's definitely possible, and this would cover that. It's primarily for the overdoses that occur. Like that's where you're going to see the prosecutions, but it would be, I think, derelict in our duty not to at least include the possibility that it could be that a cell phone could be utilized to try to set up a murder on someone, and they're going to have bigger fish to fry if they do that than just the cell phone charge. But at least it's something else that's out there that would cover that. The overdoses are what most folks are going to be charged with. Thank you.
Representative Powell.
Back to the leader. So would you have to have evidence that some sort of communication took place on the cell phone to then use that and up the charge?
Yes, unless, I'm not going to get gross here, but the way some of this stuff is smuggled into a jail or prison can
That's pretty
also
gross.
cause, it is, and it can cause death. It definitely can cause some medical issues. And so there's lots of stuff that can go wrong when stuff's being smuggled into a prison or a jail. And I think the sponsor of the bill just wants to cover all of it.
Thank you.
Representative Salinas.
If an officer were to sneak in a phone or something that would result in the death of an inmate, would they be held to the same
Yes, ma'am.
misdemeanor charges?
Yes, ma'am.
Okay. So there is no immunity.
No, ma'am.
And this would include also people that are contracted out but aren't employees of the institution?
Yes, ma'am. My understanding, that's where it's coming from. Many times is sadly correctional officers.
Okay.
Leader Lamberth, did you have another question? You were on the list. All right, Representative Russell.
Thank you, Mr. Chairman. Just to clarify, you can take a phone and make a weapon out of it too. So, thank you.
Any other questions for the sponsor? Seeing none, any objection to the question? Seeing none, we're now voting to send House Bill 1678 to judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 0 noes, and 1 present not voting.
Thank you. The ayes prevail. House Bill 1678 moves on to
Thank you,
full
Chairman.
judiciary. Item number 8, House Bill 1922 by Representative Carringer.
Second.
You're recognized. There are no amendments.
That is correct.
All right.
Ready?
Please proceed.
House Bill 1922 requires a sexual offender or a violent sexual offender to notify the owner or operator of a campground of the sex offender status prior to the beginning their overnight stay, establishes that a person who knowingly stays overnight at a campground without providing the required notice commits a Class E felony offense. With that, I'll stand for questions, Chairman.
Thank you for that explanation, Representative Powell.
Thank you. From a property rights owner's perspective, I have a question. If some, because I agree with the bill, would there be any sort of liability if, for example, the campground owner wanted to decline that rental? Could they do that based upon that, or would it simply just be the notification?
It would just be the notification. Of course, if the sex offender does not report it, there's several violations that they
Okay.
would face. But if they tell the owner and they don't register or whatever, then that would be a risk, I guess they're going to be taking.
Okay. I get, just a follow up, Mr. Chairman. I guess my only, I would hope to see that the property owner might have the ability to decline that rental and not be held liable. So maybe I'll get with you after the subcommittee to look at that. So I
Okay.
think that's important. Thank you.
Yeah, thank you.
Any other questions for the sponsor? Any objection to the question? Seeing none, we're voting to send House Bill 1922 to full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 8 ayes and 0 noes.
And the ayes prevail. House Bill 1922 moves on to full judiciary. Item number 9, House Bill 1924 by Representative Carringer. You're recognized. There are no amendments.
Thank you, Chairman and Committee. So House Bill 1924 just requires the Tennessee Advisory Commission on Intergovernmental Relations, TASER, to study the status of the Crime Stoppers programs across the state and make recommendations to enhance such programs and improve their outcome. So it just authorizes TASER to request information and input from other state and local government entities as necessary and requires such entities to comply with such requests. So that's it.
Questions for the sponsor? Seeing none. Any objection to the question? Seeing none, we're voting to send House Bill 1924 to full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 8 ayes and 0 noes.
The ayes prevail. House Bill 1924 moves on to full judiciary. Let's skip to item number 43, House Bill 2309 by Representative Carringer. Representative Carringer.
Wait a minute.
House Bill 2309.
I forgot I was on way down the line. Thank you, Chairman. House Bill 2309 just, hold a minute.
There's an amendment,
Yes,
15083. You wish to proceed with that amendment?
yes.
You're recognized on the amendment.
Thank you so much. The amendment does not make the bill. The amendment establishes criminal and civil penalties for targeting houses of worship or interfering with religious freedom. The amendment makes it illegal to use force, threats, or physical barriers to intimidate or harm individuals practicing their faith or to intentionally damage religious property. A first violation is a Class C felony and a second or subsequent violation is a Class C felony, while interfering with a religious procession or gathering is a Class A misdemeanor. So, Chairman, it just requires an additional to the sentence imposed for criminal offense of vandalism that a court may impose a fine of at least twice the total amount of any property damage, loss, or expense related to cleaning or restoration when the offense occurs at the house of worship. With that, I'll stand for questions.
Any questions on the amendment? The amendment does not make the bill.
Right.
Questions on the amendment? Seeing none. Objection to the question. We're voting to adopt Amendment Code 15083 on the House Bill 2309. All those in favor say aye. Those opposed? Ayes prevail. You adopt. We're on your bill as amended.
And so it just requires an additional sentence imposed for criminal offense of vandalism and the court to be able to do something with anything that anyone uses as force, threat, or physical barriers to intimidate or harm individuals while they're practicing their faith and or damage to religious property.
Thank you for that explanation, Representative Salinas.
Would a private school that has a chapel, or let's say it's a religious school, for example, a Catholic school, I went to a Catholic school, how would your law be applied to those properties?
Well, if they were using it as a house of worship, so, if they're in their school program, that kind of separates a little bit.
The reason I ask is, so in my high school, for example, we would sometimes have mass in the gym. Or we had a chapel, but the chapel was small. And then we also did prayer in every class we had prayer. And then we had prayer at noon when we went to lunch. So would your bill would the entire property of the school, because it was a religious school, would your law protect the entire school?
That would, what my bill says is just for targeting houses of worship. And I understand Christian schools do chapel. So this is house of worship. So that is being used as a school. So unless there are a lot of churches that meet in schools for their church services. But this is just saying in houses of worship. It's not relating to any schools.
Any other questions for the sponsor on the bill? Seeing none. Any objection to the question? Seeing none, we're voting to send House Bill 2309 as amended to full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 6 ayes, 1 no, and 1 present not voting.
The ayes prevail. House Bill 2309 as amended moves on to full judiciary.
Thank you very much, Chairman and Committee.
Item number 13, House Bill 1521 by Representative Stevens. You're recognized. There are no amendments.
Thank you, Mr. Chairman. On September 23rd, 2021, 19-year-old James Bardley Jr. was riding his motorcycle home from work. Another driver crashed into him, and he ended up losing his life. After finding the driver, he was sentenced to a period of prison, and he only served a fraction of his sentence in prison before he got on probation. And so this bill seeks to enhance the penalties for leaving the scene of an accident, especially where someone is killed. And I'm not sure if Mr. Bardley's mother has signed back up today. She signed up the first week to testify, but she is here with us today, Ms. Kim Webb. So I did want to acknowledge that she's here with us today to support this legislation. Basically, now if you hit someone and leave the scene of an accident, it's a Class A misdemeanor. And if the person dies, it's a Class C felony. This would raise each of those by 1 step. So if you leave the scene of an accident where there's an injury, it'd be a Class C felony. And then if you leave the scene of an accident where you know the person died or should have known the person died, it goes to a Class D felony.
Well, thank you for that explanation. Are there any questions for the sponsor, Representative Powell?
Thank you. And I don't know, I'd love to hear testimony, but question, do you have to knowingly know that there is injury? I know oftentimes in a car accident, and I'm like, obviously don't want to see anyone ever flee a scene, just always take responsibility. But what is oftentimes like you might the next day or say after the accident, you get checked out. And a lot of people when they're in an accident, they have a lot of different endorphins and other things running through their body and might not realize they're injured. So my question is, how would you knowingly know that that person is injured according to the bill?
Thank you, Mr. Chairman. So the way it's worded is have to know or reasonably know. So you can, if you heard Ms. Webb's testimony, I believe you would understand how this driver should have known that her son was deceased or would be deceased very soon. But I believe that the reasonable person would be able to look at the situation and determine, is this person injured or is this person deceased?
We will. Ms. Webb had signed up, so we will go out of session. Hear from Ms. Webb. If you will, come to this table here and we'll turn the microphone on for you. You will identify yourself for the record. You'll have 3 minutes for comments, and then we will open it up to the committee for questions.
Thank you. Chairman, members of the committee, my name is Kim Webb. I am a Hickman County mother, a small business owner, and the founder of a nonprofit that serves women in our community. I am here because my 19-year-old son, Jimmy, was killed in a hit and run in Rutherford County on September 23rd, 2021. According to the police investigation, the driver turned left into Jimmy's path, causing the crash, and then fled the scene. Law enforcement issued a bolo and located him later at his home 29 hours later. The court found that he saw Jimmy lying in the road and made deliberate efforts to avoid being identified. The medical examiner documented that my son was transported for emergency care and that life-saving efforts were performed before he died from multiple blunt force injuries. So this is not a story about a single moment. It's a story about a series of decisions. The other driver entered custody in December of 2023 and was released within months under current statutory structure. That outcome is not consistent with the values our statutes place on human life. And that is the gap this bill is designed to close. I'm going to veer off of here just to tell you what I told Representative Stevens in my son's accident. He hit the back of a pickup truck, ricocheted off of it into another vehicle in the oncoming lane, and then was thrown from there into the road another 30 feet. And then skid, thank you so much, skid down the road. If that isn't reasonable assumption that he is very injured or dead, I don't know what is. There is no absolute assumption he was on a motorcycle. Pretty safe to assume. If he's in a car, you're right. But this only applies to reasonable assumption. I'm going to skip this part because I veered and I don't want to go over. Jimmy's Law is a limited common sense sentencing floor that strengthens accountability, supports prosecutors, and ensures that the value of a human life is reflected in the outcome without expanding government or creating new bureaucracy. It is a narrow fix. When a driver knows or reasonably should know that a crash has resulted in a death and chooses to leave, it is a Class C felony. It carries a mandatory minimum 1-year sentence and a minimum $10,000 fine. Right now, there is an unintended incentive to flee because leaving can result in less accountability than staying. This bill will remove that incentive. Jimmy was 19. He was larger than life. He loved people well. He worked hard, and he was just beginning his future. I can't change what happened, but you can make sure that his life changes what happens next. It's not a partisan issue. Every family in Tennessee travels these roads. I'm asking you to move Jimmy's Law out of committee and help us carry it forward. I also have a statement from my daughter, but I'm not going to impose.
Well, thank you for your testimony and for being with us today. I have Leader Lamberth would like to speak.
Members, nobody up here that can even fathom the strength it takes for you to come into this committee and speak about your son, Jimmy. There's never a time when a parent should ever have to bury a child, especially not because somebody cowardly fled the scene. I'd like to hear your daughter's statement, if you don't mind sharing it.
Thank you. Good morning. My name is Catherine Reed. I am the sister of Jimmy Bardsley. 4.5 years ago, my brother was killed in a hit-and-run motorcycle crash. The driver of the car that hit him turned out right in front of him as he was driving down the road, watched it all happen, and left. My brother endured multiple impacts. He was thrown into the air and landed 30 to 40 feet from where he was first struck. No one could witness that and reasonably believe he simply walked away. He was either critically injured or already gone. We are here today to make sure that when someone causes that kind of reality, the only acceptable response is to stop and face consequences. The defendant in our case was located nearly 2 days later and only ended up serving a fraction of his sentence in jail. He had several charges against him, including tampering with evidence. That's the only reason that his sentence was as long as it was. That's true. The tampering carried a heavier weight than my son's life, than the fact that he did what he did and left. That really stuck for me. That was a problem for me. I share this not for sympathy, but for clarity. When the penalty for fleeing the scene of a fatal crash is minimal, we unintentionally create a system where leaving is a calculated risk. A driver who believes they may face DUI charges, prior offender consequences, or other penalties has an incentive to run because the punishment for fleeing may be lighter than the punishment for staying. That is not justice, and it is not deterrence. Tennessee currently classifies hit and run resulting in a fatality as a Class E. Our proposed felony. Our proposed legislation keeps that classification, but proposes a lengthier, I think she's mistaken here, but a lengthier minimum sentence of 1 year and a minimum fine of $10,000. Knowing this is the minimum punishment in our state would make people take pause in their split-second decision to leave or to stay. Our proposal is not extreme. States like Florida, South Carolina, and Georgia already impose stronger consequences. Our state should not be one where leaving the scene of an accident carries a lighter punishment than tampering with evidence or a first-time DUI. This bill is about accountability. It is about removing the incentive to run. It is about ensuring that when someone makes the devastating choice to leave a dying person behind, there is a clear and serious punishment to face. No law will bring my brother back, but we can prevent families from facing the compounded pain of loss followed by inadequate justice. I respectfully ask you to support stronger minimum penalties for hit and run resulting in fatality so that fewer families have to face this in the future. Thank you for your time and consideration.
Leader Lamb.
Thank you, Mr. Chairman and ma'am. Thank you for sharing your testimony with us today. Thank your daughter for us. And I will tell you that just for me, based on your testimony, man, I'm not a co-sponsor of this bill currently, but I will be, and I'm about to sign on. And I would ask that anybody on this committee that votes for this bill sign on to it today. So that Representative Stevens knows that he doesn't stand alone in this, and neither do you and your family, but that we stand with you.
Thank you so much. We do also have a petition of, we've just reached 2,400 signatures of other Tennesseans that agree.
Thank you,
I
ma'am.
appreciate it.
Representative Powell.
I too want to thank you for your testimony, and it's always, first of all, again, I'm sorry for your loss, but also admire your courage for people that have experienced a loss like that to then come up here and bring, I mean, that's what this is all about, is justice and making sure that we have laws that reflect the consequences of somebody fleeing a scene, and particularly when someone in the situation you happened with your son should definitely not have done that. I mean, this is a big problem beyond just when it results in death, as people are in these accidents.
I
And
feel like it's on the news more and more all the time.
it is. And I will say the positive news to all this, though, is that there are increasing technologies that allow us to witness and come back and investigate and hold more people accountable.
Yeah, a license plate reader is how we got our guy.
Yeah. So, and yeah, that's good to know. Actually, was the one that passed that bill for license plate readers in our state. So, thank you. I appreciate that. And again, sorry for your loss.
Thank you.
Any other questions for our guests? Seeing none, thank you for being with us. There is a sign-on sheet going around, members, for this bill. So thank you for being with us.
Thank you.
Without objection, we'll go back into session. Any questions for the sponsor? Seeing none. Any objection to the question? Seeing none, we're now voting to send House Bill 1521 to full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 8 ayes and 0 noes.
The ayes prevail. House Bill 1521 moves on to full judiciary. Item number 15, House Bill 2147 by Representative Jones. You're recognized. There's an amendment code 13671. Do you wish to proceed?
Yes.
You are recognized on the amendment.
Thank you, Mr. Chairman. HB 2147 addresses a growing concern raised by school districts across Tennessee. The use of drones hovering over school campuses during the school day with no clear explanation, accountability, or ability for schools or law enforcement to respond. When an unknown drone is hovering over the school, school officials are left wondering whether someone is mapping entrances and exits, tracking student movement, or capturing images or video for potentially harmful purposes. At present, there is a gap in the state law that leaves schools without protection and law enforcement without clear tools. The bill does not attempt to regulate airspace or ban drones over schools, which is outside the state's authority. Instead, it just takes a narrow, targeted approach focused on intentional surveillance by creating a Class C misdemeanor.
Thank you for that explanation. Any questions on the amendment from the sponsor? Seeing none, any objection to the question? Seeing none, we're now voting to adopt amendment code 13671 on the House Bill 2147. All those in favor say aye. Aye. Those opposed? The ayes prevail. You adopt or on your bill as amended.
the bill, that was the explanation because the amendment rewrites the bill.
Very good. Any questions for the sponsor, Representative Salinas?
I just have a clarifying question. So this is if they don't, if it's unidentified, right? If there's, let's say, a municipality that has a drone, because there's one municipality in my county that does, it wouldn't affect them, right?
Are they flying, if they're flying it over the school and they use that footage for harmful use, it would impact them.
It would, the person flying the drone or the municipality?
Who, is Noah here? There he is. I'm not sure. I can,
Nolan is signed up
yes.
to speak.
We can go
So
out of session.
We can get that
yeah.
question. We'll go out of session, hear from Nolan Combs, if you will. Introduce yourself for the record. You'll have 3 minutes for comments, and then I'm sure Representative Salinas will have a question for you.
Sure. Nolan Combs with the Tennessee School Boards Association, and I was stepped outside if someone wouldn't mind repeating the question.
So there's a municipality, for example, in my county that has drones. If they were to fly it over a school, is that okay? Does this law apply to that drone because it belongs to the municipality?
So I think that's a good question, and it's one that was asked when we were drafting the bill. And I think that we've managed to not include that in what would count as an offense, according to what's written, because the drone use would have to be, one, capturing images or video, two, the user would have to have an intent to surveil the students or property. And that wouldn't likely be the case with the municipal government who owned and managed that drone.
But if a person, let's say a rogue employee, were to get that access to that drone and use it for bad purposes, it would apply.
I think very much if they were operating in their personal capacity and using that drone with the intention of conducting surveillance on school grounds, then yes, unless they had permission from the school or the district.
Okay. Can legal clarify that first part of the question?
We can. We're out of session, so we can hear from legal services.
Michelle Fogarty, Legal Services. So the bill makes it an offense to knowingly use a drone with the intent to conduct surveillance of the school grounds without the permission of a school administrator, the director of schools, or the director's designee. And then it also states that it does not apply to a law enforcement officer acting within the scope of their lawful duties.
So if they have permission, okay. I have a little bit of issue because sometimes people go into schools. And so the reason why I found out about this drone is because I was canvassing and then a drone came in and I was like, what? I didn't even know that the city had drones. And if someone were to be going into a school without getting permission and the drone goes in, that potentially could put the municipality.
If they had the intent to conduct surveillance of the school.
Thank you.
Representative Powell.
Thank you. Question. I have Antioch High School was in my district. And unfortunately, it was a tragedy. We lost a student there last year. If someone was trying to surveil to say, understand the characteristics of the building and entrances and exits, would that also apply? Or is it, I mean, because it says surveillance, but in that case, yeah, just like clarity that would also apply. Because I do have concerns about people operating drones to try to better understand the layout of the school.
So that was one of the reasons why this bill was brought up. Not specifically the incident in Antioch, but we had calls from school board members in East Tennessee where they were concerned after having drones fly over their property for an extended period of time that they were possibly capturing images or videos of students, but it was also possible that they were mapping entrances, exits, student schedules, and things like that, like you're mentioning.
So if school was out and somebody was flying a drone, even without the presence of students, the bill would still apply. If it was found they were sort of trying to do it. Okay, thank you.
Any other questions for our guests while we are out of session? Seeing none, we will go back into session. Thank you. Questions for the sponsor on the bill as amended? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 2147 as amended to full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 0 noes, and 1 present not voting.
The ayes prevail. House Bill 2147 as amended goes on to full judiciary.
Thank you, Chairman and committee.
Item number 18, House Bill 1538 by Representative Stinnett. You're recognized. There's Amendment Code 14528. Do you wish to proceed with that amendment?
Yes, sir.
You're recognized on the amendment.
Thanks, Chairman. We talk about drones. This is about drones also. While Tennessee Department of Corrections have made progress in reducing contraband in state prisons, drones have continued to create problems for us. This bill would allow the prisons of illegal drones to take them down. It would also be a punishment of 3 to 15 years in prison and a fine up to $10,000 for persons who are using drones illegally to drop contraband into the prisons. There is the amendment allows it does not apply. This would not apply to branches of the military forces in the state of Tennessee and emergency management agencies, what the amendment is about. And so with that being said, I stand for questions, Chairman.
Well, thank you. We're on the amendment. Questions on the amendment? Seeing none, any objections? Seeing none, we'll vote to adopt Amendment Code 14528 on the House Bill 1538. Those in favor say aye. Those opposed? Ayes prevail. You adopt. You're on your bill as amended. Anything else you'd like to add?
No, sir.
Questions for the sponsor? Seeing none. All right. We're voting to send House Bill 1538 as amended to full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 8 ayes and 0 noes.
The ayes prevail. House Bill 1538 as amended goes on to full judiciary.
Thank you, Chairman.
Item number 25, House Bill 2481 by Representative Parkinson. You are recognized. There are no amendments.
Thank you, Mr. Chair and committee. What this bill does is it allows the DA's committee to purchase software licensing for both county county DAs and state DAs if they so wish. That's what it does. Oh.
Now, will you repeat what you said, please?
Yes, sir.
Thank you.
What this bill does is, thank you, Mr. Chairman. What this bill does is it allows the DA's conference, if they so wish, to purchase software for both county employee DAs and state employee DAs in the event that they need them. And it allows them to get everybody on the same software.
Thank you for that explanation.
Yes, sir.
That stylish headwear
couldn't hear me.
I couldn't hear you. Yeah,
I couldn't even hear myself.
Couldn't hear you out from under
Right.
that brim there. Yes,
Right.
sir.
Sounded like Charlie Brown's teacher. Yeah, I understand.
Any questions for the sponsor on the bill? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 2481 to full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 7 ayes and 0 noes.
Ayes prevail. House Bill 2481 moves on to full judiciary.
Chair, thank you, committee.
Yes, sir. Item number 28, members, House Bill 1689. The member has reached out to me. He would wish to take that off notice. Item number 35, House Bill 2140 by Deputy Speaker Zachary. Don't see him. Let's move down to item 41, House Bill 2263 by Representative Martin. You have a motion, a second. You recognize there are two amendments. How do you wish to proceed on those?
There are two amendments filed, Mr. Chairman, but I'd like to run the bill without the amendments.
He would like to proceed without the amendments. Very good.
Thank you, Chairman of Committee. House Bill 2263 adds starvation resulting in the death of a livestock animal to the types of conduct that constitute a Class E felony of aggravated cruelty to a livestock animal. Starvation is not a momentary act, but an extended failure to provide basic care. And when this results in the death or injury, it constitutes severe neglect that fits aggravated livestock cruelty. This does not include normal husbandry practices, market decisions, drought challenges, or veterinary care, but explicitly including starvation. This bill gives law enforcement and prosecutors clear authority to address the most egregious cases, reinforcing Tennessee's values of stewardship, responsibility, and humane animal care. And with that, Mr. Chairman and committee, I stand ready for any questions.
Thank you for the explanation. Any questions for our sponsor? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 2263 on the full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 8 ayes and 0 noes.
Ayes prevail. House Bill 2263 moves on to full judiciary.
Thank you.
Let's go back to item 35, House Bill 2140 by Deputy Speaker Zachary. You recognize there is an amendment code 13344. You wish to proceed with that amendment?
That is correct. Yes, sir. Thank you, Mr. Chairman.
You're recognized on the amendment.
Thank you, Mr. Chairman. The amendment does make the bill members. Since 2017, Tennessee has led the nation regarding organized retail crime. Just about every year I come before you because of the advancement of criminals. I come before you to advance our legislation. This time it's no different. This simply puts a mandatory minimum requirement for those who use a firearm and also increases the penalty. With that, I stand ready for questions.
Thank you for that explanation of the amendment. Questions on the amendment? Seeing none, any objections? Seeing none, we're voting to adopt amendment code 13344 on the House Bill 2140. Those in favor say aye. Aye. Those opposed? Ayes prevail. You adopt. We're on your bill as amended. You've explained your bill.
Yes, sir.
Questions for the sponsor? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 2140 as amended to full judiciary. Has everyone voted? Does anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 8 ayes and 0 noes.
Thank you for that. House Bill 2140, the ayes prevailed. It moves on to full judiciary.
Thank you, Mr. Chairman. Committee.
The bill as amended moves on to full judiciary. Let's jump to item 51, House Bill 1346 by Representative Reeves. I saw him looking through the door just a moment ago. All right, we can. Representative Scarborough.
Thank you, Chairman. And I'm sorry if out of order, but we'll take this moment to pause to recognize our police officers did arrive. Chief Deborah Turner, Donna Turner's in the front row, and we got some officers here to the left as well. Let's welcome them again, please.
Representative Reeves, you have a motion and a second. Are you ready to rock and roll?
Thank you, Mr. Chair. Yes, I think I am. This is well, first of all, I've got an amendment on the bill, if that's okay, Mr. Chair.
All right, there's two listed here. Which one you wish to proceed with?
15358.
15358. All right, you're recognized on the amendment.
Thank you, Mr. Chair. So this is a bill brought to me by a local circuit court judge who oversees the 21st Judicial Recovery Court. And I know we waited to file this bill. This section of code was rewritten last year, but it still seeks to solve a narrow problem that's created by the language of the bill. If there was ever a DUI after 1989, in fact, I think even before that, it prevents a later expunction of an unrelated offense. And what this bill says is that that later, if somebody has had a prior DUI, that they are eligible for expunction for things that are normally eligible for expunction at least 10 years following that DUI. It does not expunge a DUI, to be clear. It is 10 years after, and they have to successfully complete a recovery court program, and they have to complete any term of imprisonment or probation and pay all fines and restitutions. That's what the bill says.
Very good. We are on the amendment. Any questions for our sponsor on the amendment? Seeing none, any objection to the question? Seeing none, we're voting to adopt Amendment Code 15358 on the House Bill 1346. Those in favor will say aye. Aye. Those opposed, ayes prevail. You adopt or own your bill as amended. Questions? I guess you have explained the bill. Leader Lamberth.
Thank you, Mr. Chairman. I was going back and forth with legal, and I guess this is what comes up sometimes when you've been down here a few years. Chairman, I vividly remember a bill that we had a couple of years ago that addressed, I think, the very issue that the sponsor is trying to address of having an otherwise eligible offense, somebody who's never been had an expungement before, and having an otherwise eligible offense come after an ineligible offense and thus be blocked. In fact, the situation that I remembered was that we had a member that had a constituent that had a DUI, then years later had a misdemeanor theft. And they were blocked from having the misdemeanor theft expunged because they previously had a DUI. And I remember that bill coming through. But when looking at the code and kind of looking at legal, now if you want to go to legal to try to answer that, I think that's what this, maybe to the sponsor, Mr. Chairman, my question would be, is that the situation you're trying to resolve just for those that have completed recovery court?
Yes, sir, it is. And the way I read the statute, which, by the way, is a complicated statute, it is a lot less complicated than it was last year. I believe it still does block that from happening, and that's what we're trying to give effect to. As you know, recovery courts are extremely effective, and they cost significantly less to the state in terms of having somebody in and out of jail, and that's why I've brought this legislation.
Mr. Chairman, do you mind going legal with that very question on if this were to pass, what changes does it make in the statute? Because we've got two different amendments here, one of which it went on, and I tried to kind of give them a heads up because it is an intricate question. But here's what I don't want, and this is our law enforcement members who are here today, and several of them. I do not want them working really hard to get somebody arrested, investigated, bring their case to court, they get a conviction, and then later on, because we messed something up in the expungement statute, it just goes away as if it never occurred for somebody that really should not be getting an expungement. So.
All right, we will go out of session to hear from legal services. Almost said service there, but we're out of session. Do you want to restate the question, or is legal ready to rock and roll?
I've stated it 2-3 times over the last 10 minutes, so they probably know what I'm looking for. But
Michelle Fogarty, Legal Services. So under current law, under 4032-107, the offense you're seeking to expunge has to have occurred prior to the ineligible offense. This bill carves out a special section, creates a special circumstance for persons who are seeking to expunge an offense that is eligible for expunction and occurred at least 10 years after the person's conviction for a DUI offense. They have to have met all the requirements of their sentence. They have to completed a certified recovery course, paid all their fines, and met all the conditions of their release. So it's creating a special carve out for those persons who have a DUI conviction that occurred at least 10 years after, wait, I'm sorry, I'm getting confused. The offense they're seeking to expunge must have occurred at least 10 years after their conviction for a DUI, and they must have only had one DUI conviction. I think what you are thinking about is in 4032-107, there is language that says a person is an eligible petitioner if the offense for which the person is seeking expunction occurred prior to any conviction for a criminal offense that is ineligible for expunction, but it only applies to drug offenses.
In this particular bill, are we specifically only talking about what I refer to as post-conviction expungement? So does it affect pretrial diversion or judicial diversion in any way?
This only deals with expunction.
So no, it wouldn't affect the other two at all?
Correct.
Okay. Thank you, Mr. Chairman.
Any other questions for legal while we are out of session here? Seeing none, we're going to go back into session. Any questions for the sponsor, Leader Lamberth? Did that answer your, you have any other?
Mr. Chairman, best as we can. I mean, it's a difficult thing for legal for law. I mean, lawyers litigate this stuff all day, every day in court because we have made the expungement statutes quite intricate. So this will be one more intricacy, but I think the sponsor's heart's in the right place.
I will say the statute is a lot cleaner now than what it used to be.
Thank you, Mr. Chairman.
Yes, it is. Any other questions for the sponsor? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 1346 as amended to full judiciary. Has everyone voted? Does anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 8 ayes and 0 noes.
The ayes prevail. House Bill 1346 as amended moves on to full judiciary.
Thank you, Chair and Committee.
Representative Salinas, did you have a question? Okay. I thought you threw your finger up there. All right. Item 44, House Bill 2126. Representative Alexander, you are recognized. There's Amendment Code 13107. Do you wish to proceed with that amendment?
Yes, I do, please. Thank you, Chairman.
You are recognized on the amendment.
Thank you. Chairman and committee, this bill came to me because of a situation we had in Johnson City. We had a constituent who had property. There was an encampment, and that resulted in property damage. If you remember, a few years ago, we passed a bill that people could not encamp under our roadways and in our parks and in public places. And so what has happened because of that bill is they are seeking out private property that they hope that no one's going to see them on, and they're encamping there. What happened to our constituent was he was trying to get it cleaned up. The city, after they moved out and they got him away, the city then charged him $10,000 for that cleanup. And it wasn't the private property owner's fault. And so it just is that we need to have some rules in place for when this happens. So what this bill does is it engages in camping on private property that they do not have consent and should be reasonably know that they do not have consent, which means the property owner has to post no trespassing signs on their property. And as a result of the camping, the property is damaged, vandalized, defaced, and littered upon. What will occur is that the violation of aggravated criminal trespassing is a Class A misdemeanor. If found, the property owner has incurred expenses to clean or repair the damage caused by aggravated criminal trespassing, the defendant must be punished by the following mandatory minimum periods of confinement at 100%. First offense, no less than 30 days. Second offense, no less than 60 days. It allows for a person sentenced to participate in a drug recovery court program that is certified by the Department of Mental Health and Substance Abuse or another licensed treatment program. A participant in a program may receive sentence credit up to full minimum required. The court should strongly consider ordering service of a program for an individual that has been sentenced under the aggravated criminal trespassing charge unless found not suitable for or cannot participate in a court or program of that nature. In addition to any penalty, the court may require the defendant to clean or repair, may require the defendant to clean or repair the damage to the private property that resulted in that offense. A property owner who is victim of aggravated criminal trespassing is not liable to a political subdivision of the state or an agency with a political subdivision for the cost or cleaning or repairs required for that offense. The court may require cost and cleaning of repairs be paid by the defendant as restitution, does not establish a duty for any political subdivision or agency associated to clean or repair the private property. And that's what this bill does.
Any question for the sponsor on the amendment? On the amendment? Okay. Representative Powell.
Thank you on the amendment. So can you, I'm trying to understand why we would be having drug recovery court part of this, or the people that are doing the camping. I mean, are we assuming that they need that, or why is that included in the
It just gives the court an option instead of putting them in jail to send them to a drug recovery court if they find when they have trespassed that there's needles and that they're using drugs, or that they need some mental evaluation and help. So that's why the mental health part of it is.
Okay, so just for clarification, that is just an option.
It
not
is. It's a
necessarily-
may, not
Okay.
a shall.
Gotcha. I see that now. Okay, thank you.
Any other questions on the amendment for the sponsor? Seeing none, any objection to the question? Seeing none, we're voting to adopt Amendment Code 13107 on the House Bill 2126. All those in favor say aye. Those opposed? Ayes prevail. You adopt or on your bill as amended.
Just ask for a favorable.
Any questions for the sponsor on the bill as amended? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 2126 as amended to full judiciary. Everyone voted. Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 6 ayes, 1 no, and 1 present not voting.
The ayes prevail. House Bill 2126 as amended moves on to full judiciary.
Thank you, Chairman. Thank you, Committee.
Let's go to item number 58, House Bill 2354 by the Chair Lady Littleton.
Motion.
You recognize there are no amendments.
Thank you, Mr. Chairman. This bill prohibits probation for any person convicted of sexual battery by an authority figure.
Any questions for the sponsor? Leader Lambert.
Madam Chairman, I'm just going to say again, and I know this is your last year, but I mean, thank you for bringing these type of bills. And I hope that there's somebody that will step into the breach next year and bring this type of legislation, because I can't imagine a judge out there that would be sitting on the bench and have someone convicted of sexual battery by an authority figure. I mean, a horrible violation, and then give that person probation. But apparently there's judges in this state that do that. So there's bills that are needed to say, clearly that person should not be on probation. They should be in prison. So thank you for bringing the bill. I appreciate it. Again, I just hope after your retirement, somebody steps up and brings these type of bills, because you look at the code, it seems like every day looking for improvements that are needed like this. And I know you sit on committees and task forces that look for this type of stuff as well. That's where you get these bills. So just thanks for bringing the bill.
Any other questions for the sponsor? Thank you. Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 2354 to full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 8 ayes and 0 noes.
The ayes prevail. House Bill 2354 moves on to full judiciary. Is Representative Kumar out there?
Next, we have number 62, House Bill 2367 by Chairman Doggett. Properly motion and second, you are recognized, Chairman Doggett.
Thank you, ma'am.
And I see no amendments, is that
There are
right?
no amendments. This is a victims package that we have been working on, and it's going to help us get in the proper posture that in the event that the Marcy's Law constitutional amendment passes on the November ballot, that we will be ready to go as a state when it comes to certain things that deal with victims and through the judicial process. And if there are any detailed questions, be glad to assist with that. I have people that are here to speak on it, but that's what we're doing.
Thank you for that. Everyone's worked really hard on this bill, and we look forward for it to move forward with more encouragement and good things. Leader Lambert, you're recognized.
Thank you, Madam Chairman. And actually, if the District Attorney's Conference is on the list, I would like to hear from them on this particular bill on how it does implement Marcy's Law, because I know that was a concern that came up early on, and I'd just like to hear that on the record if we can.
Without objection, we'll go out of session. Would you please come forward and state your name and who you're with, please? Minutes.
Brittany
Good morning.
LaValle, I'm the Deputy Director for the Tennessee District Attorney General's Conference. So many of the things in the package will assist now with the current law that we have in place. Thank you, sir. This is going to help us in part one for victims to be present in all the areas where defendants can be present. So occasionally victims will be excluded from the courtroom during those times, and this will assist in that. It's going to allow our law enforcement in part two to receive restitution when they expend funds for purchase of drugs or things like that when they're in their investigations. Currently, that is an area in the law that needs to be fixed. It's also going to provide for the coverage of some additional crimes, vehicular homicide resulting in bodily injury and reckless conduct. It's going to provide for victims assistance in those areas. And the final area it'll provide for in retaliation for past action. Under that statute, currently, it does not cover victims as one of the people who are included in that statute. So it'll add that to the statute.
You're recognized.
Stephen Crump,
several
Executive
questions.
Director, Tennessee District Attorneys General Conference. You're going to see more legislation like this proposed by the conference next year once the implementation takes place. But these are the things that we can anticipate on the front end as the first sort of line of things that we're going to see. We don't know all of the needs that Marcy's Law and the enabling statute that will come from that will create, both for victims and for law enforcement. But we thought it was important to start the process with these things because they are things that we absolutely know will be, that they frankly exist now. And once Marcy's Law is in place, we'll be in a position to more adequately care for victims and law enforcement.
So I know at some point the conference had some particular issues with Marcy's Law. I mean, are y'all comfortable with it now with some of this implementation language?
Yes, Leader. Thank you very much. We worked closely with the folks from Marcy's Law. The first version of Marcy's Law, frankly, weakened Tennessee's constitutional amendment, we believed. Over a long period of time, we talked with them about those issues, about how we felt like there were places that there were strengthening that could take place. And so we're glad to say that we are fully in support of Marcy's Law and have issued, I think, statements to the effect endorsing it and asking Tennesseans to vote for it.
Good. Thank you.
Are there any other questions for our guest? Seeing none, are we ready to go back into session? We're back in session. Chairman Doggett, you're recognized.
Well, thank you, Chair Lady. And like I said before, the Marcy's Law has not been voted on yet. And for some reason, if it was to fail as a constitutional amendment, having these types of things in there for victims is going to be a win-win for everyone going forward. So I believe it is going to be good public policy either way. So thank you.
Are there any other questions for Chairman Doggett? Representative Scarborough, you're recognized.
I just want to thank the sponsor for bringing legislation, and anything we do to help our victims is worth it. So thank you, sir.
Any other questions? Are we ready to vote? All those in favor of House Bill 2367 moving out to full judiciary, let's vote. Would you please open the board? All those in favor, vote aye. Those opposed, no. Madam Clerk, would you please take the vote?
Madam Chair, you have 8 ayes and 0 noes.
Thank you, Madam Clerk. House Bill 2367 moves out to judiciary. Full. Next up, we have number 63, House Bill 2377 by Chairman Doggett. Properly motion and second. I see there are no amendments.
That is correct.
Lucky you. So you're recognized.
Well, thank you. We are revising the offense of continuous sexual abuse of a child. The bill modifies the statute by reducing the required duration from 90 days to 30 days and simplifying the statutory structure. This change maintains, excuse me, it maintains the legislature's original intent to treat continuous sexual abuse of a child as a single continuing course of criminal conduct, while lowering the artificial evidentiary barrier that disproportionately affects cases involving young children. It's going to focus on patterns of conduct rather than that of the more rigid timeline. So with that, I stand ready for any questions.
Are there any questions for Chairman Doggett? Seeing none, are we ready to vote? Well, all those in favor of House Bill 2377 moving out to full judiciary, please vote yes. Those opposed, vote no. Madam Clerk, would you please take the vote?
Madam Chair, you have 8 ayes and 0 noes.
House Bill 2377 moves out to full judiciary. There's one more. It's not calendared. No.
Let's go to item 66, House Bill 2567 by Representative Kumar. You are recognized. There are two amendments. Do you wish to proceed with one, both?
Yes, Mr. Chairman.
None.
Amendment 015718.
Amendment Code 015718. You have a motion and a second on that amendment. You're recognized.
Thank you. This is a cleanup and follow-up bill for Public Chapter 520 that we passed in 2025 to create the persistent domestic violence offender registry. Over a period of time, this has been very well received, and we have received calls from various other states that want to do the similar registry. We were the first in the country to do that. And again, the response also from various groups that are involved with the problem of domestic violence in our state has been very positive. During that meantime, we have received suggestions from them as well as TBI operationally how things are working. And this is a clean-up bill that takes those suggestions after evaluation and puts them in adds them to the current law. The key changes include clarifications on convictions that constitute a defendant being placed on the registry, clarifications on specific time period a defendant is placed on registry, and also clarifies that prior convictions in other states do count towards the registry. It makes other changes to what the court clerks documentation the court clerks have to send to TBI, as well as the matter of when payment is due. With that, Mr. Chairman, I'm happy to answer any questions.
Thank you for that explanation on the amendment. Questions for the sponsor on the amendment? Seeing none. Any objection to the question? Seeing none. We're voting to adopt Amendment Code 15718 on the House Bill 2567. Those in favor say aye. Those opposed? Ayes prevail. You adopt or on your bill as amended. I think you may have explained your bill.
I think I did.
Okay.
Yeah. So if any other questions on the bill, I'll be pleased to answer.
Any questions for the sponsor? Seeing none. Any objection to the question? Seeing none, we're voting to send House Bill 2567 as amended to full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 7 ayes and 0 noes.
The ayes prevail. House Bill 2567 as amended moves on to full judiciary. Item 67, House Bill 2574 by Representative Kumar. You're recognized. There is an amendment code 15606. You wish to proceed with that amendment?
Yes, Mr. Chairman.
You're recognized on the amendment.
Thank you. The amendment basically makes the bill.
Okay. Well, I'll tell you what let's do. Let's go ahead and adopt the amendment, and then we'll talk about the bill.
Thank you.
All those in favor of adopting Amendment Code 15606 on the House Bill 2574, say aye. Those opposed? Ayes prevail. You adopt your own bill as amended, and you are recognized.
This is also a small cleanup bill. Last year we encountered the problem that when a person is stopped for driving under intoxication, getting their blood test as well as breath test at that time can be difficult because of their resistance. And the advice to law enforcement at that time was that they're allowed to use reasonable force to restrain them and obtain the tests needed. However, law enforcement's hesitant and it is vague about what is reasonable force. And this law changed that, and instead of expecting law enforcement to use their judgment and reasonable force that can be questioned, the law that we passed last year was that a person would be informed that if they do not follow the implied consent requirements, then instead of their license being suspended for 1 year, it can be 18 months. At that time, we meant to apply it to blood as well as breath test, but however, breath test was left out. Now we are adding that to the current this cleanup bill. And thank you, Mr. Chairman.
Questions for our sponsor on the bill as amended? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 2574 as amended to full judiciary. Oh, yeah. Everyone voted? Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 5 ayes, 0 noes, and 2 present not voting.
The ayes prevail. House Bill 2574 as amended moves on to full judiciary.
Thank you, Mr. Chairman and committee.
Leader Lamberth.
Thank you, Mr. Chairman. And to the members of the audience, one of the reasons we're moving around today is that obviously we are there are 2 chambers and both are equally important, the House and the Senate. And there are a number of bills that are not showing as on notice, even in calendar in the Senate. And so I've had a couple of senators that have come in. You've probably seen me bouncing around a bit that have asked questions about that. But with, Mr. Chairman, I think there's 85 bills on the calendar today. At some point, there has to be some triage go on trying to get members that are moving in both chambers. So the chairman has had to make some tough decisions and try to get things moving along today. And I appreciate your leadership in that, Chairman. But I just wanted at least an explanation, because I've even had, even just now, an esteemed member of the Senate come in and say, well, no, it's on notice. And I pulled it up on the website and it's not on notice. And so, man, I don't know what's going on with the systems or whatever. But Mr. Chairman, I appreciate you leading us through it, because it has been a challenge, I think, to just try to make sure stuff's moving in both sides. So that's what we're trying to do. And I appreciate it, Mr. Chairman. I just wanted to say that out loud, because I've had a lot of questions about it from members and everybody else on why didn't it show on notice? Well, whatever shows on the system is what we have.
And thank you for that. And we're looking for Representative Grills, which he is not here, and Chairman Farmer. Let's go to item number 84. I'm going to hand the gavel back down to Chair Lay Littleton.
Little Lambert, you're recognized.
Madam Chairman, only one other thing on that. One of my own bills is stuck in that same posture. So I have a senator that is insisting that the bill is on notice. I've checked 14 times during this committee and it doesn't show on notice yet. So I'm struggling through the same situation that other members are.
Okay, next we're going to call up item 84, House Bill 2374. Chairman Doggett. Chairman Doggett, you're recognized.
Thank you. I don't believe there's any amendments. This is a cleanup to the FTA fix that we've had for several years now. It removes the requirement for a defendant to be placed on a state or national federal database such as NCIC if the fugitive from justice on a bench warrant or a capias due to their failure to appear for certain offenses authorizes rather than requires the court to relieve the surety of a liability for undertaking the defendant has not been placed on the available state or federal list. And it restores a 10-day time frame for the process to go between the date of the failure to appear and then from that time in which the local sheriff should have, or police department should have that information entered into NCIC.
Are there any questions for Chairman Doggett? Seeing none, are we ready to vote? Madam Clerk, would you open the board? All those in favor of House Bill 2374, vote aye. Those opposed, no. Anyone wish to change their vote?
I'm trying, lady.
There we go. Anyone want to change their vote? Madam Clerk, would you please take the vote?
Madam Chair, you have 8 ayes and 0 noes.
Thank you, Madam Clerk. Your House Bill 2374 moves to full judiciary. Item 85, House Bill 2480. Chairman Doggett, you're recognized. I don't see an amendment, so you are recognized.
Well, thank you very much. This bill would replace 5 grant-funded social worker positions with the Tennessee District Public Defenders Conference. Those positions are set to expire in June. And so what this is doing is setting it up with permanent funding from the state to have those positions in the judicial districts of the 1st, 7th, 12th, 22nd, and the 29th.
Are there any questions for Chairman Doggett? Representative Powell, you're recognized.
Thank you. Is there some equality to way the number of social workers, do you know, that applies across the judicial districts? Is it on par with the other ones, to your knowledge, if you know?
To my knowledge, these were all grant funded just to help, I guess, with caseload and some other things. And that grant was set to expire, but it was such a great program that they were asking if they could get those permanently funded so they could continue to offer those services.
Okay, thank you.
Any other, did you have any more? Representative Powell? Any other questions for Chairman Doggett? Seeing none, are we ready to vote? All of those in Madam Clerk, would you open the board? All those in favor of House Bill 2480, vote aye. Those opposed, no. The ayes have it. Madam Clerk, would you take the vote?
Madam Chair, you have 8 ayes and 0 noes.
Thank you. So the ayes have it. So your bill moves on, House Bill 2480 moves on to judiciary full.
Let's go to item number 38, House Bill 2101 by Chairman Faison. You're recognized. There are 2 amendments.
One amendment.
Well, I'm showing 2, sir.
Well, I'm going to trust you, Mr. Chair.
Which one would you like to go with? I'm guessing 15433 is the one you
That's the one I like.
All
Yes, sir.
right. You're recognized on the amendment.
Thank you, Mr. Chair. This amendment does write the bill. We live in a society that just about anything you need can be brought to you by card these days. I'm amazed from the time I started living in the Cumberland till today, you see them coming breakfast, lunch, and dinner and all in between, carrying everything there. What we're doing with the committee's indulgence is allow our senior citizens and people who don't ever otherwise really want to make it out to be able to get Sudafed, keeping with the same rules that we currently have with the amount of pseudoephedrine they can buy. And then the other thing this bill does is currently it's called the MPLEX system. And it's rare that we put an actual business name in the code. We're just taking that out and replacing with electronic sales tracking system. And that's basically what the bill does, Mr. Chair.
Well, very good. That is an explanation of the amendment. Any questions on the amendment? Seeing none, any objection to the question on the amendment? Seeing none, we're voting to adopt Amendment Code 15433 on the House Bill 2101. All those in favor say aye. Those opposed? Ayes prevail. You adopt or own the bill as amended.
Question on the bill?
Any questions for the sponsor? Representative Howell.
Just a question. So that, the amendment totally makes the bill not as is now? Okay.
Yes, sir.
That's it.
Yes, sir. I mean, if you look at by deleting all language after enacting clause.
Okay, gotcha.
Any other questions, Representative Powell?
No, that's it.
Okay. Any other questions for the sponsor? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 2101 as amended to full judiciary. So everyone voted? Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 8 ayes and 0 noes.
The ayes prevail. House Bill 2101 moves on to full judiciary. Members, let's go to item number 69. House Bill 1980. Representative Grills, you have a motion. There's a second. You recognize there is no amendments. Have at it.
Thank you, Mr. Chairman. Sorry to be running late. It's been a busy morning. As introduced, this allows the court to temporarily revoke a defendant's bond and order the defendant to be held without bail for no more than 10 days pending bail revocation. The hearing if the defendant violates condition of release.
Mayor Lamberth.
All right, so we passed several bills that deal with this on folks that violate conditions of bond. We've made it a new crime. We've definitely made it so that they can revoke bond. Does this address the issue when somebody is out on an ROR and they commit a new crime, and does it allow the judge to go back and change that? Which part of the statute is changing on this?
Thank you, Mr. Chairman. It's my understanding that after a defendant has been released on bond and then violates the court's trust, then they get brought back.
Sharon, can we go to legal real quick?
All right, we will go out of session to hear from legal services.
My question is, so y'all have crafted a lot of these bills over the years. What does this particular one change? Because I know the member's not on this committee, so how does this mesh in with the other bills we passed in years past?
Michelle Fogarty, Legal Services. This one states that if the defendant is released upon their personal recognizance on an unsecured personal appearance bond or any other bond approved by the court and they're charged with an offense committed during the release, or they engage in conduct that results in the obstruction of the orderly and expeditious progress of the trial, then the court may revoke their bond and order them held without bond for no more than 10 days pending a bail revocation hearing.
Yes, sir.
And therefore, it absolutely in no way precludes a new charge of an misdemeanor violation of bond conditions or a full revocation of the bond. Is this just an intermediary measure? Is that basically what it's doing here?
Yes, it goes on to say the court may permanently revoke their bond and order them held without bail pending trial.
Okay. All right. Thank you.
Any other questions for legal services? We'll go back into session. Any questions for the sponsor on the bill? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 1980 to full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 6 ayes, 0 noes, and 1 present not voting.
The ayes prevail. House Bill 1980 moves on to full judicial. Let's go to item 79, House Bill 2079 by the Chair Lady Littleton. You recognize Amendment Code 15666.
Well, that's scary, but yes, sir.
And a second, you're recognized on the amendment.
Thank you, Mr. Chairman. This creates a Class C felony offense if a person, for the purpose of deriving a pecuniary benefit, engages in conduct intended to influence the occurrence of or non-occurrence of an event while the person or another in the party to a contact with a predictive market by which the person will benefit directly from the occurrence or non-occurrence of the event. That's what the bill does.
Any questions for the sponsor on the amendment? Representative Powell?
Yes, I do. Could you, I'm not familiar with prediction market. Could you give me an example of what a prediction market is?
Yes, ma'am.
It's if you know the outcome of, like, if they're betting on something or race or whatever, and you know the outcome, and you bet on it for them to win or lose, to
Okay.
make a profit.
So increasingly, I know you can basically, there are platforms where you can bet on multiple things outside of just sports. So say, for example, you knew the outcome of, that would apply, or what are we trying to get
I
at?
think it would apply.
Okay, thank you.
I'm sorry.
Any other questions on the amendment? Seeing none, any objection to the question? Seeing none, we're voting to adopt Amendment Code 15666 to House Bill 2079. All those in favor say aye.
Aye.
Those opposed, ayes prevail. You adopt your own bill as amended. Any questions for the sponsor? Yes, sir, Leader Lamberth.
And I apologize, but back to legal if we can, Mr. Chairman.
All right, we will go out of session to hear from Legal Services.
All right, so my question, if you're familiar with it, I mean, there's a U.S. Supreme Court case, I believe, that is pending. We're pending some sort of a decision on prediction markets and how states can regulate them right now. Are y'all familiar with where the posture of that is, or at least where the circuit court has ruled and how this might affect that?
I am not overly familiar with that, but this bill criminalizes the person who influences the occurrence of the event that the prediction contract is based on. Like, so if the person that commits this offense has to influence the outcome to their monetary advantage. If that makes sense.
So for instance, like a player in a sport or a candidate in a race or something of that nature, like someone who is, say someone's running for public office or something like that, and they know something's going to happen and then they change this prediction. I mean, and then they bet on whatever this prediction market's going to do. Is it kind of what this is going to?
Yes, they have a contract on the prediction market and they do something to influence the outcome so that they get the monetary benefit, the pecuniary gain.
Chairman, I'm going back to my childhood, and Pete Rose is coming to mind here. I mean, and I hate to say his name out loud like that, but I mean, I remember a pretty big scandal where he was coaching a baseball team and supposedly bet on it, and the argument was that he changed the outcome. I think his argument would be that he absolutely did not. But is that kind of what we're talking about here, but with prediction markets?
Yes.
All right. And Pete Rose is not watching this committee, but if he were, I apologize. He was a childhood hero, and it broke my heart when all that happened. So thank you.
Any other questions for Legal Services while we're out of session? Seeing none, we're going back in. Back in session. Chair Lady Littleton, anything you need to add?
No.
Any questions for the
Favorable vote.
sponsor? Seeing none, any objections? Seeing none, we're voting to send House Bill 2079 as amended to full judiciary. Everyone voted. Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 7 ayes and 0 noes.
The ayes prevail. House Bill 2079 as amended moves on to full judiciary. We're going to go to item number 16, House Bill 985. Representative Renault. For those of you who are watching, the Senate has just dropped their final calendar and is being updated as we speak. So this bill is listed on there. You are recognized. There is an amendment code 14033. Is that one you wish to proceed with?
Yes, Mr. Chairman.
And a second, you're recognized on the amendment.
The amendment just extends the effective date until January 1, 2026.
Okay. January.
July 1, 2026.
July
Just
1.
moving
Okay.
it,
Yeah.
yes.
I was going to say we're going back in time here. All right. Any questions on the amendment? Seeing none, we're voting to adopt amendment code 14033 on the House Bill 985. All those in favor say aye. Those opposed, the ayes prevail. You adopt your own bill as amended. Please explain.
Thank you, Mr. Chairman, committee. Currently, under Tennessee law, a person who is otherwise lawfully carrying a firearm can commit a Class B misdemeanor punishable by a $500 fine simply by walking past a properly posted no firearm sign. If that individual holds a handgun permit, the Department of Safety is required to suspend or revoke that permit. There is no harmful act that has been committed at that time. There is no refusal to comply. There is no criminal intent, just simply crossing a threshold. This bill removes that automatic criminal penalty and the mandatory permit suspension. Property owners still maintain full control over the premises. They may post signage, they may deny entry, they may ask someone to leave, and they can contact law enforcement. If a person refuses to leave, then that becomes the criminal trespass and officers can act immediately. This bill also simplifies signage requirements. Instead of prescribing specific statutory wording, it allows individuals, businesses, and establishment and government entities to post clear signage advising that firearms are prohibited and the entry may be denied or a person may be required to leave. This legislation simply ensures that the criminal penalty follows a refusal to comply, not merely just walking past a sign. So with that, I stand ready for questions.
All right, we do have some here that wish to testify on the bill, so we will go out of session. Hear from a Graham Tudor and a Toby Meyer. All right, we'll hear from you, sir. If you would introduce yourself for the record, you'll have 3 minutes for comments and then open for questions.
Good morning. My name is Graham Tudor. I'm the Director of Legislation for the Tennessee Department of Safety. The Department of Safety has some serious concerns with this legislation, as well as the other executive branch agencies. We feel this will allow more guns in state offices. So as the sponsor described, it will no longer be a criminal offense if an individual enters a state office that has postage. So the burden is now going to fall on state offices to have screening at every entrance, which we don't currently have and certainly don't have the funding right now in the budgets to do that. If someone does enter with the firearm, our only option would be to trespass the individual, which would essentially require us contacting law enforcement. So again, we don't want individuals entering state offices armed where tensions can already run high. That includes, driver service centers or child care facilities under DCS and various state offices around the state. I'm happy to answer any questions.
All right, questions for our guest, Representative Powell?
Thank you. So if someone was to say, go into if this bill was to pass, say, there was somebody like an employee exiting a side door and somebody entered, then under that circumstance, we would not be able to, you basically would have to just you'd have to have post up security at every single point of access to the building. Is that correct? To just make sure that people aren't carrying firearms?
Yes, sir, that would be correct.
Okay. And one other follow-up question here. So as it presently stands, if somebody does try to enter and they have a firearm, what happens under that process?
It would be a criminal offense And this strikes out that criminal offense, and then they could also have their handgun carry permit revoked.
Okay. I mean, I just think like applying this to say, flights, right? Which is different. It's not under your purview, but like, I think about this as like, what if everybody could just kind of try to walk on board a plane with a gun. And clearly there's defined security lines, but the whole point is to make sure that people don't even have the ability to do that. Because obviously we've seen what happens when people are able to take firearms onto planes. So I think it creates a separate major issue where now you're putting the burden on the state to try to deal with the situation. So I appreciate your answer, but I see why law enforcement would be very concerned. Thank you.
And I speak for state offices, but this would also apply to any, local governmental building as well as private businesses.
So it could apply to schools as well?
I'm not sure the answer to that.
Thank you.
Representative Scarborough.
Thank you, Chairman. Is it appropriate for me to ask a question of the sponsor?
We'll ask the sponsor a question when we go back into session, if
Very
that's
good.
okay
Thank
with you.
Thank you.
Any other questions for our guests while we're out of session? Seeing none, thank you. Mr. Toby Meyer. Okay. Well, all right, then you missed out. We'll go back into session. All right, Representative Scarborough,
To the sponsor,
Yes.
I remember the conversation I had with her earlier. Would you speak to the intent when you talk about where they can and can't carry and I think you're talking about private businesses, correct?
Go ahead.
Thank you, Mr. Chairman. Well, first, if I could just address that there's nothing in this legislation that changes the way that how enforcement would work in practice. If someone were to enter a place now, whether it's a private business or a government entity with a firearm, if someone is carrying today and they refuse to leave, law enforcement would be called. If this legislation were to pass and if someone is carrying under this legislation and refuses to leave, law enforcement would still be called. Even if now, if someone is carrying, no one in the government building is going to apprehend that person. They are also still going to call law enforcement. So this, in practice, the enforcement, the way that we would enforce this does not change under this legislation. It does not change court building application or the established other gun-free zones in statute like education. And this would not apply there. Those already have their own provision. This applies to all other gun-free zones that are outside of the legislated ones, that people do have the right to say whether they want someone to come in or not with a firearm. What I'm simply asking is that the automatic criminal penalty be removed if they walk in and don't see a sign. If they're asked to leave, then they would be under criminal trespass, and absolutely law enforcement could be called, and then that penalty would apply.
Representative Scarborough.
So this doesn't distinguish between a private business and a public building like a jail or a football stadium or something like that.
If it's already in statute, an established gun-free zone through statutes such as education, it does not apply to those.
So then it would be a violation of the law if they did that. It wouldn't have to be asked. You could actually prosecute at the point, right?
You wouldn't be prosecuted, but the removal of the misdemeanor and the permit loss would still apply in those situations. These are for gun-free zones that are established by private property, so like business owners and whatnot.
Representative Powell.
For the sponsor, I think actually this does fundamentally change the way we do things, because right now there's a presumption that everyone is coming through, say in this building, I mean, there's a metal detector and there's a process there. Now people could enter through other access points, and no longer would the public have the presumption that those people were not unlawfully carrying firearms. So essentially, that would completely shift the burden to the state, and even the faith that the public has to make sure that everybody is going through the proper security process and being screened. Now you would have people that could come into the building and you wouldn't know who was armed or unarmed. So I think it does fundamentally shift the entire process.
Thank you, Mr. Chairman. In the legislation, it actually specifically does state that, at public entrances to property, metal detection devices, or security officers, for those establishment that do offer those, then they can uphold the gun-free zone. Like that is already in statute. I think Leader Lamberth actually passed that. So this does not change that. And if I can, Mr. Chairman, I'd like to just point out that this legislation would actually put Tennessee in line with all other states. Texas, Florida, Georgia, they also do not allow enforcement until a person refuses to leave. So we're not saying a business cannot do this. You would still have the right to ask someone to leave. We're just saying that if someone walks past one without seeing the sign, they do not automatically become a criminal, and they wouldn't automatically lose their permit.
Well, I guess my response to that is the permit process comes with certain responsibilities that the permit holder should uphold, right? So you have to be a responsible person and you have to go through the proper permitting process to have that. So as a permit holder, you should know that you should actually go through the proper process to enter into a building. Now you would have people that could not be responsible permit holders and not be held accountable for coming into a building through a side door or some other access point. So I think that, if people are having these permits, then they should be upheld to the standards that are in the permit already. And this diminishes the entire point of a permit. So for that, I just have opposition to the bill.
All right. Anyone else? Leader Lamberth.
Mr. Chairman, I know we're running low on time here, but I've talked to the sponsor several times. My opinion, I think there's a cleaner way to do it. I mean, like for instance, your bill as amended takes out some of the signage requirements, and we fought hard to get those in the statute so that they're in there at a certain size and everything else. And I was talking to legal about that on making sure that so much of that is still in there. I'm worried about what we're taking out doesn't accomplish entirely what you want to do. It's a good concept. I support what you're trying to do here. I would have probably recommended to just put an intent requirement in it and kind of let the statute alone. Say you have to intentionally, violate the signage posting. Balancing private property rights and our civil liberties that are protected by our government, which is the oath that we take, and provided, I think, even prior to the formation of this government, is a critical role for us. And I know that's something that you cherish and I do too. I also cherish someone's private property rights to do with their property as they see fit. So I know you're trying to balance that here. So appreciate the effort. I support the effort, but it's the language is still a little messy in my opinion. So.
Yes, ma'am.
Thank you, Mr. Chairman. The language actually does not take away the right for them to put up a sign. It just simplifies it. Instead of saying specifics on what the signage has to be, we're just simply saying they can do it and actually removing some of the specificity in what they have to do. And I would just like to point out that, when someone walks in past a sign that says no shirt or no shoes, you're not immediately charged with a crime either. They have to ask you to leave. And then only if you leave do you become trespass. So we don't criminalize the moment of entry for a dress code violation. And I don't think we should do it either for a constitutional right. When it comes to private property rights and self-defense, I 100% agree. Private property owners do have the right to set the rules for their own property, but individuals have the right to carry. So that's why I believe you put the statute in that if they were going to limit your right to carry, then they would provide protections like security or metal detectors. I feel like this legislation still honors the property right owners that they can trespass someone if they do come on for refusal. But if somebody walks past it unintentionally or unknowingly, then we shouldn't criminalize citizens or lawful abiding carriers without notice. And that's all we're asking to do is they just have to get notice to become a criminal.
Yes, sir.
Oh, again, I'm not debating or disputing anything you just said. It just, a friend of mine that I served with a few years back fought real hard to get that signage in there at the size that it is. That's all I was referencing, that it does take that out. We felt like that signage needed to be very prominent. That's all I was saying a while ago. So.
Representative Salinas,
Oh, I just had a question on the bill.
you're recognized.
Question on the bill.
Question's been called. Any objection? Seeing none. We're voting to send House Bill 985 as amended to full judiciary. Has everyone voted? Does anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 5 ayes and 2 noes.
The ayes prevail. House Bill 985 as amended moves on to full judiciary. Members, we are out of time, beyond time. I apologize, and I'm thankful for your patience today, but all bills today that were not heard will be rolled to next week's calendar. We are adjourned.